Okay, today we are presenting Divorce Basics in Nevada. I'm Molly Rosenblum. I own Rosenblum Allen Law Firm here in Las Vegas. I've been a family law practitioner for over 20 years. Our office specializes in family law and criminal matters. So let's get into the basics of divorce in Nevada. So a definition of divorce in Nevada can be found in the Nevada Revised Statutes in primarily section 125, which talks about what divorce is. But divorce essentially ends a legal marriage. It is the ending of the marriage, unlike an annulment, where an annulment makes it like the marriage never exists. Divorce is the end of a marriage. In Nevada, there are 3 legal reasons that people can get divorced, and those legal reasons are incompatibility, insanity, and living apart. Under Nevada law, most cases that you will see are filed with incompatibility. And what that means is that the marriage just isn't working out. You don't have to give a reason. You can just say that you are incompatible in marriage and that there is no possibility that you will reconcile. And the Nevada judges can take that as a basis to terminate your marriage. You can make an argument for insanity, but you do have to prove that your spouse was insane for 2 years prior to filing for divorce. You can include insanity as a basis for marriage, but you will be required to prove that with a medical provider's affidavit or declaration. The other basis is living apart for a year. If you and your spouse have not lived together for over a year, you can use that as a basis to get divorced in Nevada. Nevada does have a residency requirement, and that is found in our Nevada Revised Statutes at 125.020, and that explains the legal requirements for residency. But if you are watching this webinar, what you need to know about residency is that you have to be a Nevada resident for 6 weeks prior to the filing of your complaint for divorce. Typically, if a court is questioning your residency, they are going to ask you to provide proof of residency. That can mean a mortgage statement, that could be a deed to a home or a lease with your name on it, a driver's license from the state of Nevada, or even like bank records, phone bills, something that shows that you have some tie and some residency in the state of Nevada. And not only do you have to be a resident for 6 weeks prior to the time that you file your complaint, you or your spouse must remain in the state of Nevada or have an intent to remain in the state of Nevada through the divorce proceedings. There's been a lot of litigation in our jurisdiction about the intent to remain in Nevada after proceedings have started. Most courts will not force you to stay in Nevada once your case has been filed. So if you and your spouse both want to leave the jurisdiction, typically what the court's looking for is one person to stay here, at least for the majority of the time that their case is remaining. If you and your spouse have children, your children must be here for 6 months prior to filing your complaint for divorce. That is federal law. And if the children are not here for 6 months, there is a whole host of other things that our courts will look at. Like, is there another jurisdiction that could take jurisdiction over the children? Should the court bifurcate your divorce? But just know that if your kiddos haven't been here for at least 6 months prior to the filing of your complaint for divorce, you may not be able to establish custody as part of your divorce case. Nevada is a community property state, and community property generally means all assets, everything, assets and debts that were acquired during the marriage. So in Nevada, anything that you purchase with your spouse or purchase in your own name during marriage is presumed to be community property. And what that means is that you and your spouse, have an equal ownership interest in the asset and are equally responsible for the debt. But like everything in the law, there are always exceptions, and we'll get into those in a second. The Nevada Revised Statute regarding community property is Nevada Revised Statute 123.220. And it says that all property other than separate property acquired by either spouse after marriage and before a decree of separate maintenance or divorce is community property. So Nevada law requires us to divide things equitably, and usually that means equally, unless there's a reason not to divide it equally. And again, we'll talk about that in a second, but just understanding that community property means that whatever you buy or owe during your divorce is considered community, and it will likely be split 50-50 unless the court can find a reason to divide it otherwise. On the other side of that is separate property. So separate property means assets or debts belonging to one spouse only. That can be something that you got before the marriage or after the date of separation or through an inheritance or gift. Those things could be considered separate property. Separate property means that it stays with the person who originally had it. So for example, if you purchased a car before you got married and paid it all off before you got married, and it's only in your name, that car is probably going to be considered your separate property when you divorce. And again, we find the definition of separate property in Nevada Revised Statute 123.130, which defines separate property as property owned by a spouse before marriage, acquired after marriage by gift, inheritance, or devise, or acquired by a spouse after separation of the spouses, and that remains their separate property. In Nevada law, if you start to commingle your separate property with your community property, it may no longer be considered separate property. So what that means is that, going back to our car example, you have a car, you purchased it prior to marriage, you paid it off, but then you got married and put your spouse's name on the title. That car may be considered community property because you put your spouse's name on the title. We usually see this with real property, real estate, houses, land, where somebody owns the property prior to marriage, has their name on it, but then they use their community funds. They take money from a joint bank account with their spouse and pay down their mortgage. And at that point, their spouse may acquire a community interest in their separate property. But that gets a little more complicated and is beyond what we're talking about here today. So understanding that with regard to property, Nevada follows the principle of equitable distribution. The judges look to make a fair distribution of assets and debts during the marriage. And while stuff is supposed to be divided equally by default, the court can look at different factors to award more community assets to one spouse or to order another spouse to pay more of the community property to the other spouse. Things that the court will consider are what both parties are leaving the marriage with. For example, if one spouse is leaving with $1 million pension and the other spouse is leaving with a $20,000 pension, the court may look to award the spouse leaving with less, more of the community property. In any marriage or any divorce in the state of Nevada, we have to consider alimony, and most people are surprised when we tell them that alimony is not guaranteed. In Nevada, there is no promise that any spouse is going to get alimony. When our courts look at alimony, they consider a number of different factors. The easiest ones to look at are the length of marriage and the financial needs and earning capacities of each spouse. Generally, I tell clients who are doing consultations with us that if their marriage is under 5 years, the chances of them getting alimony is pretty small. It can be done in some cases, but in most cases, a 5-year marriage or less, you're not getting alimony. The other situation that the court is going to look at that's the easiest for the judges to say yes or no to alimony is the financial needs and earning capacities of each spouse. So even if you have a 25-year marriage, if you both earn the same amount of money, the chance of you getting alimony is pretty small. After that, the court will look at the standard of living during the marriage, how old each spouse is, whether one spouse has a health condition or a medical condition that keeps them from being able to work or earn as much as the other spouse, how much each spouse put into the marriage, whether there's been any prenuptial agreements or postnuptial agreements signed, and then whether or not they're earning income earning assets between the spouses. And then also the court will look at specialized education obtained by one spouse during marriage and then any other factors. So kind of breaking those down, if you are a spouse, I had a case where a client was married for 15 years. During the marriage, her husband obtained a pilot's license. He was able to earn significantly more than she was. And the court awarded her lifetime alimony because her husband had obtained that pilot's license during marriage. And the court thought that she should benefit from her supporting her husband through his specialized education. The income earning assets piece of the alimony equation usually causes people some concern. And typically what the court is looking at is, are you getting retirement accounts, investment homes, investment accounts that are going to give you money during the marriage so that you don't need alimony? Then the court will look at the types of alimony that can be awarded. So there is temporary alimony, permanent alimony, and alimony can be modifiable or non-modifiable depending on the circumstance. So again, what type of alimony you end up with will depend on the circumstances of your specific case. And if you wanted to look up the alimony awards and how the court considers alimony, that can be found in NRS 125.150, 125.180, and 125.1502. All talk about alimony in the state of Nevada. After a divorce decree is finalized, some people want to change their alimony. Either they can't afford to pay it or a spouse may want more. What Nevada law says is that if there has been a substantial change, in circumstances, the court can modify alimony. And that is also if your alimony award is modifiable. If you've made your alimony non-modifiable, it is very, very difficult to change your alimony award. Usually where we see this as practitioners is when a spouse has lost their job and can no longer afford to make their alimony payments. They may want to seek to modify their alimony. So in Nevada, the legal process for filing a divorce is as follows. First, you would file a complaint for divorce. Some jurisdictions may call it a petition or a complaint, but basically you tell the court why you want the divorce. We go back to those three things, either insanity, incompatibility, or living apart for 1 year, and what you want from the divorce. Do you want all of the community property? Do you want half the community property? Do you want alimony? Do you not want to pay alimony? And those kinds of things. So all of that goes into your complaint for divorce. And then you would need to have your spouse served. So this is what's known in our jurisdiction as service of process. And we have to have your spouse personally served, which means you can't just mail them the documents. Someone over the age of 18 has to serve them with the documents. And that person who's serving can't have an interest in your case. So it shouldn't be your adult children. You should try to find a friend or an extended family member who can serve that. Once the complaint has been served, you have to wait for a period of time for your spouse to respond. And then they will file a response and maybe a counterclaim. This is known as an answer and counterclaim. In the answer and counterclaim, they will either agree with what you've asked for in your divorce complaint or disagree. And if they disagree, then you are what we refer to as contested divorce litigation. You will have a hearing with the court, and the court will set a schedule for you to do discovery and gather evidence. What the court is looking for is proof of your assets and debts, and probably proof of your residency. So you should be looking for things like bank records, deeds to property, mortgage statements, proof of your bills, and anything else that you would need to prove your case to the court. Then you have the option to attend mediation. And if you go to mediation, you can help find a mediator who can facilitate a settlement of your case. If you're unable to settle your case, you would have a pretrial conference and then a divorce trial, and ultimately you will submit a decree of divorce, which is the final document in any divorce proceeding. So we've listed out some reasons why people like to go to mediation to try to settle their case, and why we think that mediations are a good idea in Nevada divorce. Typically, it's more cost effective. It is faster than going through a contested case. It's less adversarial. And most of the time, it gives you more control over the outcome of your case. In addition to that, mediation is confidential, and it's less emotional, or can be, for the litigants than going through a trial and listening to your spouse get on the witness stand and talk about what a terrible spouse you are. Mediation doesn't allow for that. They're looking to reach agreements and compromises. And finally, we've included a list of our divorce frequently asked questions to answer your questions and go a little deeper into the divorce in Nevada. And that will conclude our presentation on Nevada divorce basics. If you are looking for an attorney to assist you with your divorce case, please feel free to give us a call at 702-433-2889.